judicial review of parliamentary privileges and defining the role of the courts in respect of parliamentary privileges have been described as the most difficult aspects of the parliamentary privileges. Carney states, there is lack of coherent principles to define precisely the jurisdiction of the courts. No doubt, partly as a result of the paucity of cases where this issue has been raised. But even in those few cases where the issue has been decided, there has been a tendency not to articulate clearly the reasons for denying or accepting jurisdiction. When jurisdiction is denied, at times it seems that judges have been too willing to shy away from the spectra of conflict between Parliament and the courts. There has been in past acute controversy between House of Commons and the courts over the issue of privileges. After a series of conflicts, it now appears that the controversy can be taken to have been settled to a large extent by agreement between the Judicature and the House of Commons. The following propositions have emerged. A. Each House of Parliament is the sole judge of the question whether any of its privileges has been infringed. But whether a house does in fact possess a particular privilege is a question for the courts to decide. B. In the exercise of its power to punish a person for its contempt, either house commits a person for contempt of privilege which is not specified in the warrant. For example, unspeaking warrant. And the courts are powerless and they have no power to examine its legality. C. Neither of the houses is alone competent to declare the extent of its privilege, and this is subject to judicial determination. D. While the mere pronouncement by the House of Commons that it has a certain privilege will not be accepted by a court as conclusive. Once it is established that a matter is within the privilege of the House, the court will not interfere with its exercise. E. If a House issues a special warrant, it would be open to the court to consider whether the reasons set out in the warrant amount to contempt or not. In India, the controversy between Parliament and the courts came up for the consideration before the Supreme Court in the famous advisory opinion in reference under Article 143 AIR 1965. Article 105, so also Article 194 subjects the powers, privileges and immunities of each house as well as all its members and all its committees not only to the laws made by the appropriate legislature but also to all other provisions of the Constitution. The powers of that the House can claim must be shown to have subsisted in the House of Commons on 26th January 1950, and it should be further shown that such claims were recognized by the England courts. Secondly, not all the powers and the privileges which belonged to House of Commons on 26 January 1950 can be claimed by the state legislature under Article 194 Clause 3, because the former is sovereign and the latter is subject to the provisions of the Constitution.